We'll now turn to member questions. The chair now recognizes himself for 5 minutes for questioning. Mr. Dowd, I really enjoyed a recent conversation I had with Acting Comptroller Sue, and I appreciate his thoughtfulness on this topic. As I communicated to him, my view is that it far too often takes 12 months or more to approve a merger transaction, and in some instances even longer than 12 months. Ironically, my Democrat colleagues contend that this long, drawn-out process is a mere rubber stamp. But isn't that just too long, Mr. Dowd? Can you describe some of the negative consequences for shareholders and employees when applications are pending for a long length of time?
Thank you, Mr. Barr. I appreciate the question, and it is a very important question in terms of how the federal banking agencies consider bank merger applications that are in front of the agency, and our coordination with our peer regulators at the Federal Reserve, the FDIC, and the Department of Justice. I will say that in general, the complexity of the application is highly correlated to the timing of a decision on the application. So when you think about the bank merger applications and business combination applications that come before the OCC, the vast majority of those are processed in what I would characterize as a very timely and quick fashion.
Well, just reclaiming my time, Mr. Dowd, for those that are not processed in a timely manner, the concern is that customers, shareholders, and employees of the target bank are left on the hook indefinitely to see share prices drop and employees depart. We've seen this recently with target banks. To avoid this, can you or the OCC support legislation that ensures applications are processed in a timely manner and deemed complete in a set time frame? I'm from Kentucky, and we like basketball. It's kind of like a shot clock. We'd like to see a shot clock. It can be a no. The answer can be a no. But the regulatory purgatory, the indecision, is what we're concerned about here.
Understood, and I think the analogy is one that I relate to, and I would think many at the OCC relate to. I do have a Knicks fan behind me, so we'll dispense with that for a moment. But I was born in Springfield, Massachusetts, the home of the Basketball Hall of Fame.
Very good.
I am very familiar with the concept of a shot clock. More importantly, I am familiar with the legislation that you and your staff have been working with the OCC and our staff on. I believe that we have had some very productive discussions on that front, and I think we look forward to continuing those discussions with your staff. And I think there are many important and valid ideas for consideration in that proposal.
Thank you. I look forward to continuing to work with the OCC on that, and I value that collaboration. Mr. Dowd, let me talk about these community benefits agreements. In current law or under the OCC's proposed rulemaking, does a bank need to have entered a community benefits agreement in order for you to conclude that the merger application would meet the convenience and needs of the community?
The short answer is no. I will say that the engagement between banks involved in a merger application and community benefit groups can be very helpful in terms of thinking forward on the convenience and needs factor, which is obviously one of the 5 statutory factors that has to be considered and has to be reconciled before there is a decision with respect to approval on a bank merger act. So in general, they can be helpful.
Yeah.
They are not necessary.
And this is actually where the rubber meets the road. I mean, even if it's not required as a matter of law or policy, it's still required as a practical matter in cases where a community group has filed an adverse comment on a merger application. And my concern here is that the agencies are outsourcing the convenience and needs prong of the statutory review factors by requiring a community benefits plan to get merger approval, even if it's just de facto, and that effectively confers upon the community groups a great degree of leverage to extract favorable deals, sort of a blackmail or extortion situation, if I may state it frankly. Maybe the OCC doesn't see it that way. Certainly community groups don't see it that way, but I can tell you that banks that face thwarted deals see it that way. Are you all sensitive to that?
We are sensitive to it. We consider it one part of of the process. And I will conclude by saying we do have an NPR, and we welcome comments on that issue and all other related issues.
My time has expired. I've got more questions, but we'll need to move on, and I appreciate the gentleman's feedback. The gentleman from Illinois, Dr. Foster, is now recognized for 5 minutes.